evaluation. So please give us your thoughts at the end. And really look at that when we're coming up with our future. Without further ado, Mr. Kline Pillow.
Hello. Hello. Can I steal your table? All right. Leave my water. Yeah. Well, how are y'all doing today? Doing good. I'm glad you came out. Like Rebecca said, my name is Kline Pillow. I am an elder law attorney with Ross and Shoalmire here in Tyler. I moved here and opened this office about 5 years ago. A little over 5 years ago, actually. And we've actually been, working closely with the Alliance ever since we got here. And one reason for that is because the clients we serve, so many of our clients deal with issues of dementia and Alzheimer's. And so the Alliance is a great resource for our clients, and we try to be a great resource for the Alliance. So that's one reason we're here today, is to help support them and support you, and try to give you good, valuable information that you can carry with you. All right? So, what is elder law? I get that a lot. Have you ever heard of elder law before? Okay? I'll tell you a story, which is that I went all the way through law school and studied for the bar, which is about 3.5 years worth of, studying law. And I never once heard of elder law. Not one time during that whole period. The first time I ever heard of elder law was when I was looking for a job and found this one. Okay? So I think they do teach it now because there's such a need for it. But at the time that I went through law school, which wasn't that long ago, it really wasn't that well known. So, what is it? Sometimes people define it as law for the old folks. That's what I get sometimes. All right? I'll tell you what it's not before I tell you what it is. Okay? I get questions sometimes like, do I have to be a certain age to be a client of yours, to talk to you? Do I have to be an elder, a senior? And the answer is no. Okay? There's no age limit on the people that we represent. We're really trying to, if we can, pre-plan. Be ahead of things. So it's never too early to start your plans. I define elder law as planning for and through the aging process. Okay? So when do you start aging? Always, right? It's never too early to get things in order. And I'm going to give you some examples of that as we go through it. One other question I get is, well, I am a senior, therefore you must represent me in everything that comes up. That is also not what I do. I don't represent anyone in divorces. I don't defend you if you were pulled over for drunk driving. I don't really sue people. I'm not suing nursing homes. Okay? That isn't really what we're here to do. Okay? We're working with a client individually and their families to help them plan for and through their aging process. So what is that? What does that involve? Okay? I would say our practice is really split into two parts. On one side, we have the pre-planning. You're trying to get all of your things in order before it becomes an issue. The other half of our practice is more of crisis planning. You're in a situation and you need to deal with it immediately. You need to protect your assets from long-term care. You need to go to court to get guardianship of an incapacitated person. Your spouse or your parent has passed away and you need to go to court for probate. So there's things that we deal with immediately, and then we're planning for those things to try to avoid and be better prepared for them. I would say that that's what our practice is split into. Now, what are we actually planning for? I would say that everyone needs a plan for three main things. There are three things that we are really trying to plan for when we're meeting with clients. All right? So what are those three things? The first is incapacity. Okay? We're speaking here at a dementia care conference. I think we all understand what incapacity is if you're here. Okay? But at some point, a place in your life where you can't make decisions for yourself. You're unable to manage your affairs, make responsible decisions, care for your business. You need to have planned for that already. Okay? You need to have legally appointed someone to be able to do those things for you. Because if you ever get to that position in your life and you haven't, then no one has the actual right, the legal right, to assist you. And they're going to run into a bunch of problems trying to help you. And they're going to end up in court. And I don't like to go to court. A lot of the things we do is trying to avoid ever stepping foot in a courtroom. I don't like to be there. I get paid to be there. I'm assuming that the people that hire me don't want to be there either. So if we can stay out of court related to anything we're talking about, we want to do so. And the best way to do so is to be prepared and plan for that. So number one is incapacity. We want to have a plan for that. Number two is death. We're all going to die. So what happens then? What happens to my stuff? How do I ensure that my things go to the people that I want them to go to? Can we avoid having to go to probate court? My spouse or my kids. I don't want them there after I die dealing with that. I'd like to have everything set up to make that easy and efficient for them. Okay? How do we plan for that? And then number three is long-term care. Having a plan for long-term care. Okay? If you became incapacitated and unable to care for yourself, you may need to seek long-term care services. Right? The statistics say that when you reach the age of 65, of people that reach 65 years of age, 80% of people who reach the age of 65 are going to need to access some form of long-term care. So if there's an 80% chance that you need to access long-term care if you reach 65, you're probably going to want to have a plan for how you're going to pay for that. Okay? So, those are kind of the three main things we're looking to do, and they really all kind of tie together. Right? And it is very important that you have a plan for all three. But, unfortunately, for all of you here right now, I'm only going to let you pick one. All right? So we're just going to kind of do a survey to see where your heads are at on what you think is the most important thing to have planned for. Now, don't get me wrong. You need to have a plan for all three. But we just want to kind of emphasize this. We want to talk about it. Figure this out. All right? So, I'm going to make you all participate. I'm going to have you raise your hand to vote for one of the three options. Okay, then we'll talk about it. So, again, those three options are incapacity, death, and long-term care. Really fun stuff we're talking about. Okay? But it's real. It's just reality. Okay? So we might as well face that and be prepared for it. So, if you think having a plan for incapacity is the most important of the three, raise your hand. Okay? Pretty good number. Pretty good number. All right? What about a plan for death as the most important? All right? So fewer, about 5. All right? What about long-term care? I'm assuming everyone else say long-term care, but I'm going to make you raise your hand anyway. Okay? So, in looking at this survey, I would say it went a little different than normal. And maybe it's because I'm speaking today. Maybe we've experienced this, and you have, some insight into why, the why behind it. Okay? Normally, very few people say incapacity. More people say a plan for death, and overwhelmingly the majority says long-term care. Okay? And I think we had more people say long-term care today than anything else. But the one thing that was flipped was the incapacity and the death. Okay? I have an opinion on which of the three is the most important. You don't have to believe me, but this is my opinion, and this is what I do every day for work. I've seen it play out. I have an opinion. All right? So let's just go ahead and rule one of those out right off the bat. If I'm working with a client, again, the person that I'm helping is my client. I'm looking to plan for them. They're the most important person to me. All right? If I'm working with a client, and we're talking about a plan for death, when is their plan for death going into effect? When they die. Okay? Therefore, planning for death cannot be the most important, or should not be the most important thing for you. Okay? Now, you may disagree. You may say the most important thing for me is to ensure that my spouse and my kids are well set up and taken care of, and I want it to be easy for them, and that's the most important thing for me, and that's fine. Again, you should plan for all three. But there's things that are going to happen before you die. And we want to ensure that that plan for death matters. We want to make sure that we get there with our assets. We want to protect the things we work for so that we can pass those things on. Okay? So, that means we have to have a plan for long-term care, right? That's the most important. Right? Because if we end up going broke paying for long-term care, then what's the use of having a plan for death? All right? Well, let's go through a scenario there. Let's say you chose to plan for long-term care. That's your number one priority. There's only a couple of ways, there's only 3 ways that you can pay for long-term care. There's only 3. Right? Number 1, you have long-term care insurance that you've obtained and you can claim on when you need to access long-term care. Now, I don't sell insurance. I'm not the best person to ask about the right policy for you. What I know about it is great to have. It's really good security for the person when it comes to long-term care and those expenses. The issue is, all of these policies are different. They're all very expensive. By the time you think, oh, I need long-term care insurance, you may be a little bit older. The older you are, the harder it is to qualify and pass the underwriting and the medical exams. If they find anything wrong with you, maybe you're uninsurable. Maybe they jack your premiums up. Okay? It needs to be affordable for you. Certainly, if you get it when you're younger, maybe you're a little healthier, but you're paying on it longer. Just insurance. You're trying to figure out, does that work for you? But it's not just qualifying and affording it. It's, well, what exactly is it going to pay for? Some policies only pay for nursing care. They don't pay for home care. Some policies have lifetime maximums. It'll only pay up to a certain amount for your lifetime. Or a daily maximum. I see clients come in, they've got a long-term care policy, it pays $60 a day. Do you know what the average daily cost of long-term care in the state of Texas is right now? $237 a day. So if you've got a policy that covers $60 a day, you've got 1/4. You're 1/4 of the way there. Okay? So all of these policies are different. Long-term care insurance is a way you can pay for it. There are great policies. I've seen them. I've also seen really poor ones. All right? You can private pay. All right? But I meet with clients every single day. 95% of the clients that I meet with do not have monthly income in retirement that would cover the cost of their long-term care. Much less all the other expenses that they're incurring on a monthly basis. So if you don't have monthly income that covers it, that means you're dipping into the assets that you have accumulated and are living on in retirement. And have you accounted for those costs when planning for retirement? You're going to be dipping into that, which means it's dwindling. All right? So private pay. The other is qualifying for benefits that will help pay for that care. We're going to talk about that too. Well, let's focus on that long-term care insurance. You've decided the most important thing for me is to have a plan for long-term care. I'm going to go out and secure a long-term care policy. And in this situation, it's the best policy you could ever imagine. No lifetime caps, no daily maximums. We'll pay for any level of care, home care, assisted living, memory care, skilled nursing care. We'll pay for any of that. It's affordable to you. You're really secure in that plan for long-term care. All right? So what happens? What we typically see is a chain of events. First, you have your health crisis. So here, we'll say your health crisis was you suffered a major stroke. And that stroke landed you in ICU. And you were in ICU for some time period, and you were able to stabilize, and they moved you to a regular hospital room. and you were in the hospital for a little while, and then they said you can't stay here any longer, so they sent you to rehab. And so you're able to get your rehab under your Medicare, but that's only a short-term rehabilitation. It's only going to be covered for a short period of time. And eventually you'll run out of your days there. So we have our health crisis, then we have a housing crisis. I have exhausted my rehab days. Am I going to be able to go home, or am I going to need to stay? Where am I going to live? What am I able to do for myself? Do I have people that can care for me at home? All right? Here, this major stroke has rendered me completely incapacitated. My mind has not come back. I don't know what day it is. I can't use my extremities. I am totally and completely incapacitated and unable to care for myself. So I'm going to need to stay in this skilled nursing setting. Okay? So, we've had our health crisis, our housing crisis, where am I going to live? Now it's a financial crisis, how am I going to pay for it? All right? Luckily, we have a long-term care insurance policy that we can claim on that will pay for that care. Any of you here ever made a claim on insurance before? Auto, home. How does that process work? Real easy? You just call them up, hey, a tree fell on my house, they'll send you a check. What do you have to do? What does that process look like? What are you doing? Waiting? Waiting on what? Yeah. So they're not anxious to pay. And so what do you have to do? You have to follow up. You got to make a claim. Do they send an adjuster out? Do you have to submit pictures? I mean, what all is entailed there when you're making a claim on insurance? The same is going to apply to long-term care insurance. You're going to have to prove that you need it, that you meet the necessity, the requirements for a claim. So what happens? I'm going to call and say, my dad is in the nursing home, he's got a long-term care insurance policy with you, we need to start the process of making a claim. And what are they going to tell me? What are they going to tell me? I'm calling on behalf of my father.
You're not on the HIPAA.
Oh, sure, maybe I'm not on the HIPAA, but it's not my policy.
Right, he has to call.
Yeah, therefore, I can't talk to you, we need to talk to him. What's the issue with that here? He's incapacitated, he can't call. Well, unfortunately, we can't talk to you unless you have power of attorney. Okay? I believe the most important thing that you can do in your planning for the aging process is have a very good power of attorney. Okay? Because that is the one thing that you can have in place that as long as you have that person or people that you assign those authority and rights can actually help you plan for the other two. Alright? That power of attorney can consult with me to figure out a plan to access long-term care, to apply for benefits, to sign a deed to protect your home from the state of Texas if you access benefits. They can access bank accounts. They can do a number of things that can actually help you plan for death, help you plan to protect those assets, help you get qualified for long-term care or make a claim on a policy, while the other two don't. Okay? There's been many a time in that same situation where someone's exhausted days, they're in a nursing home, they're incapacitated, they need to figure out how they're going to pay for it. They are directed or referred to my office. I assess the situation. Yes, we can help. Are you power of attorney? Yes, I am. I am the executor on Dad's will. Okay? That's great that he has a will, and I'm glad that you're appointed the executor. Unfortunately, Dad's not dead. Well, not unfortunately. We're glad he's living. But as far as does this document work or not, an executor or will means nothing until you die. Nothing at all. So if all you have in place is a will, you're really unprepared for the things to come in your life before death. We have a long ways to go before we die. We need to be prepared for that. Okay? What we're going to talk about today is really the mistakes that we see our clients make. All right? I'm not going to tell you all what to do, because one, nobody wants to be told what to do all the time. But number two, we might be here for weeks if I were to tell you what to do. Because I might have to go through and tell you all something different. Because you're all in different situations. Some of you are married, some of you are single, some of you are widowed, some of you are divorced, some of you are in a blended family, some of you have no children at all. Some of you own a home, some of you rent, some of you may have long-term care insurance, some of you might not. So every single person here may have a different plan. So me telling you what you need to do isn't going to help you here. What we want to do is identify the things you really don't want to do and avoid those things. Okay? So that first idea on what to do, the mistakes we see people make, is focusing so much time and attention with their planning on a will and neglecting to get other things in place that are necessary to care for, help, and assist you while you're alive. Okay? I hope everyone here has been told they need to have power of attorney. I know everyone here has been told they need to have a will. Okay? So we just always want to beat that into your minds that if you don't have power of attorney, you need to. And not only do you need to have power of attorney, you really need to have a good. Okay? You really need to have a good power of attorney. Yes.
Okay, so like my parents, would one of their kids be able to be power of attorney for both of them, or would it be like my dad's power of attorney because he's still, and then if something happens to him, then it goes to my mom?
You can do it any way you want to when it comes to power of attorney. So you can say, I appoint my spouse, and if my spouse can't do it, then I appoint my favorite child, and if not that child, then my indifferent child.
You can have like
and
a
so forth.
succession plan, essentially.
Yeah, you can say 1, 2, 3, 4. You can say I appoint all my kids together where any of them can step in and do it because I trust them all equally. You can say, my kids don't get along that well, I'm going to appoint them all together and they have to have a majority. I would probably not recommend that. But you can do it any way you want. Okay? Yes, sir.
So along those lines, can you unpack what a good power of attorney means?
Yes.
Do you have to have somebody with a law degree? Do you have to have somebody who lives next door?
Sure.
What does it
You can appoint anybody you want to. A good power of attorney isn't necessarily, when I say that, I don't mean the person you're appointing. Certainly you want to trust them and have belief in them that they will do right by you and do what you're supposed to. You want to appoint somebody capable. But almost all the powers of attorneys that we draft are appointing a spouse, a child, a friend. Very rarely are we appointing like a third-party, private, professional, fiduciary type person. It's almost always family related. That doesn't say it has to be, but that's typical. When I say a good power of attorney, I'm talking about the document itself. A well-drafted power of attorney. It covers every situation. Okay? When I do long-term care planning, I need a really good power of attorney. Because I'm going to recommend and advise that power of attorney agent. A lot of times, I'm going to tell them they need to do things that may not be legally authorized under just a basic general power of attorney. Okay? So, good example here. All right? Basic standard power of attorney law would say it is assumed under the law that everything that power of attorney does has to be for the benefit of the person that appointed them. Right? That's a good thing. That's a general good idea. Everything you do on behalf of this person that gave you the power has to be for their benefit. Good idea. All right? Well, let's let it play out. All right? So, Dad's had a major stroke. He's in the nursing home. He's going to have to stay long term. He's got $100,000 in the bank. His child comes and sees me. Hey, what do we do? Okay? Option one You can privately pay at the nursing home until you run out of money, and then get access to benefits. Okay? Option number 2, we can work together, formulate a plan that allows for us to gift, transfer, set aside $65,000, privately pay $35,000 towards long-term care, and expedite that process for eligibility for benefits while preserving that person's estate. Okay? What option would you choose? Almost always, we're going to choose the second option. But the actual carrying out of that option may mean we're gifting money to the child, or we're putting money into college savings accounts for the grandchildren, or we're doing something that is not directly for the benefit of that person that's in the nursing home. But what would they prefer? Would they rather go broke paying for long-term care, or would they rather preserve those assets even if they're not in their name or for the benefit of their children? That's just the situation. Well, maybe we want to grant authority in the power of attorney to say, on the advice of an elder law attorney, to access long-term care benefits and access government assistance for long-term care, we are authorizing them to make gifts of my property, to transfer my property, to set up a trust, to do a number of things that may not be directly for my benefit, but carries out my objectives as it relates to the distribution of my assets when I die. We're going to go ahead and expedite that. We're not going to wait till we die to divide the money up. We're going to go ahead and gift it now. We're going to be in the same exact situation when it comes to care. We're just going to be able to work to preserve and access that without going broke first. Okay? Well, let's say you take the position of, I don't want to ever access any sort of government benefit if I have the ability to pay for it myself. Okay, let's take that approach. That's totally fine to take that approach. The government says you get to keep your house. You're not forced to sell your house. They're not going to take your house. It is your home. You can keep it under the rules. So let's say you had $50,000 and you don't go with any sort of planning. You just privately pay till you run out of money. Well, now I can get on benefits because I'm broke. Well, once I get on benefits, my check that I get $2,000 a month in income from Social Security and a small pension. All of that is payable to the nursing home as my portion, even if I'm fully qualified. All I get to keep is $60. So is $60 a month sufficient to pay for the maintenance, upkeep, taxes, insurance of the home? No. So even if you don't plan to set aside a bunch of money and access benefits, let's at least try to set aside enough money to maintain the house so that that burden of keeping up with that and those expenses don't fall on my children to then take over. Okay? That's just an example of having a good power of attorney as it relates to me and what I'm trying to do to help assist people when they come into my office in a crisis. Okay? A lot of people haven't claimed you get to keep your house. Okay? But if you die after you've accessed state benefits, the state says you can keep your house while you're living, but they keep track of how much they paid out for your care over time. So if you've been in a nursing home for 2 years and the state's paid $110,000 over 2 years for your care and you die, the state is going to immediately make a claim against your estate for $110,000. We want to work with our clients to ensure there is no estate for the state of Texas to come back and take. And most of the time that's going to be a house. So I want my power of attorney I'm working with to have the authority to sign what's called a Ladybird Deed to remove the home from the estate and allow for it to pass immediately to the kids that were named in the will to carry out the wishes of the person accessing long-term care instead of the state coming and taking the house. Okay? And we need to have good authority to sign a Ladybird. So, yes, we want a good drafted power of attorney. That is very important. Okay?
If I had a Ladybird, could the state still come after the money they have paid?
No. The state's estate's always going to have their claim for whatever amount of money they paid out. That will always exist. What a ladybird does is
Claims against me and I'm dead.
it can claim against your estate. What the Ladybird Deed does is it allows for your home to pass from you individually directly to the people named in the deed without it ever being in your estate after death. Okay? That may be confusing. So let's just go ahead and piggyback off that. Okay? I don't care about staying on topic today. I'm just here to answer your questions. So feel free to ask anything you want as we go, okay? So, great question, because it allows for me to really talk about something else. The planning for death. I realize when I meet with clients, they don't really understand how their things pass when they die. They've got a will, and they think that that is going to say where their things go, and that may not always be true. Okay? So let's take a step back and talk generally. How do your things pass when you die? All right? If I had a whiteboard up here, I'd draw a good column. I'd draw a line down a sheet of paper, and I'd separate this into two columns. So on one side, we're going to call those probate assets. You've got probate assets on one side, and on the other side, you've got non-probate assets. So you've got probate assets and non-probate assets. What does that mean? Does anyone have any idea what that means? Sure.
If it has a beneficiary, that's a non-probate item.
That is correct. Okay? What she said is if it has a beneficiary, it's likely going to be a non-probate asset. I would agree. All right? Let's just define those two things. Probate. What is probate? Probate is a legal proceeding that deals with a person's estate after they die. Okay? A person's probate estate is made up of those things that remain in a person's name after they die. And those assets are what are distributed under a will. Or if you don't have a will, under the law that the state of Texas says, here's where it goes. Okay? Non-probate assets are exactly the opposite. Doesn't require a court proceeding or legal proceeding to distribute the asset. Doesn't really remain in your name after you die. Is not distributed under your will. Okay? So, let's just take, for example, I am married. All right? Before I married my wife, I had a son. So I have a son separate from my wife. She also had a son before she married me. So I have my son, I have a stepson, and then we've had a child together. So we're a blended family. She's got a child outside of my marriage to her. I've got a child outside of my marriage to her. We have a child together. All right? When I got hired at Ross and Shoalmire, I was not married. I had one son. Okay? And so, through my employer, I have a 401k, which means I contribute money out of my check every month. They match it. That is my retirement plan. When that was set up, I needed to name a beneficiary. Okay? At that time, I named my son. All right? So time goes by, I get married, we've got a child, hey, we need to do planning. So we go and we get wills and we say everything to each other, and then after we're both gone, equally to the 3 kids. That's what our wills say, all right? I die. If I never change the beneficiary on my retirement account, it's going to pay to my child. It does not matter what my will says. Because I had an account, I specified on that account specifically where it goes, it's going to pay to who was listed. Does not matter what my will says. And that's going to apply to so many things. My bank accounts. Are they jointly owned? Did we add our oldest child that lives here on our bank account? Because if so, and they survive us, then that child owns the money. It's not subject to the will. Okay? Bank accounts, retirement accounts, investment accounts with your Edward Jones or Ameriprise or anywhere else, you likely have beneficiaries on those. Your life insurance, your annuities, almost any type of financial asset that has an account, you can name a beneficiary. Those are all going to pass immediately upon your death, outside of your will, outside of court. Okay? So what are probate assets generally? Your home. How do you own your home? You have what? You have a deed. And when you die, your name is still on that deed. So then you need to figure out whose name's going on the deed now that I'm dead. Okay? Your will would control that. Your card, your stuff, your land, your stock certificates that you own that you never converted digitally to a broker somewhere. Your mineral rights, a number of things could be probate assets. Or your bank account that didn't have a beneficiary. Or your life insurance that you had payable to your estate as the beneficiary. So it's not always that you're on one side or the other. It just depends on how you set it up. But I've just seen so many people think, oh, I've got a will. That covers it. But you've got other types of ways that your things pass. Does that make sense? Okay? What we asked about is a Ladybird Deed. How does that work? Okay. A Ladybird Deed is the perfect tool to protect your home from the state of Texas if you ever get on long-term care benefits. Because you're allowed to keep your home. But you don't want to own it when you die. And you can't give it away before you die, or you just disqualified yourself from getting access to benefits. I've seen this happen a lot. And this is why good powers of attorneys, people that deal with all of this, are very important. Not to try to hype myself up, but we just deal with all of it. I'm not just an estate planner. I'm not just a long-term care planner. We deal with all of it. So I don't know how many times I've had to go reverse something someone else has done. Another return. Okay? So what happens in that situation where dad has a stroke, he's in a nursing home, he's going to have to stay, he needs to get on benefits. Well, what people have heard is, that the state's going to take the house. People have heard that. They're scared of that. So they go see their family attorney who has represented them in a divorce or a DUI or any little thing that they've ever needed. He did their simple wills and their simple power of attorney. And they go see him and they say, we don't want to lose the house. And he's like, I got it. They can't take the house if dad doesn't own it. So we're just going to go ahead and deed it to the kids today. And then 3 days later, the nursing home sends the family to talk to me to figure out how to get on Medicaid to pay for it. And when I'm asking questions about what does the family own, what does dad own, does dad have a house? And they're like, they kind of hesitate. And they're like, yeah, he does. I'm like, well, what do you mean? He did, he doesn't. Yeah, we just deeded it to ourselves 3 days ago. I'm like, well, you just disqualified your dad for 48 months. You just disqualified. It'll be private pay now for 48 months unless it's fixed. You got to deed the house back to dad. The home is exempt. Doesn't count. If I give the home away and it's worth $200,000, I've just put myself in a penalty for 4 years in which I have to private pay. So we have to give it back. It has to be exempt on the front end. How do you prevent the state from coming back to take it when you die? You use a Ladybird. So what is a Ladybird Deed? It's just like this. What's your name, man? Carol? Okay. I'm Kline. I own my home. I'm going to do a deed on my home today to Carol. I'm going to deed it to Carol today. However, and this language is in the deed, however, for the rest of my life, it's my house. And not only can I just live there and possess the house, it is 100% totally still my house. I can live there and possess the house. I can rent it. I can mortgage it, reverse mortgage it. I can sell it. I can give it to Courtney. All right? I can do whatever I want to with the house. It's mine. If I want to sell it, I don't have to ask you. You don't have to consent to it. You don't have to agree. It is still totally mine to do whatever I want to it for the rest of my life. If I sell it, I get 100% of the proceeds. You get nothing. It's totally mine. Okay? What you have is this remainder interest that upon my death, all of those rights that I retained for my lifetime, I'm not living anymore. They fully vest in you immediately upon my death. So as soon as I die, you own all the rights that I have. And I have done the deed before I die. It's like naming a beneficiary on your home. Okay? The state looks at that and says, well, you didn't give it away because you have the right to live there and the right to sell it and lease it. And if you did sell it, all the proceeds go to you. So it's still your home. It's still your homestead. It's still exempt. We're not penalizing you for doing that deed. And then their claim after you die is against your estate. And because it transfers immediately to Carol upon my death, it was never part of my estate. It was never had to go through court. It's not subject to creditor claims, like the state of Texas or anything else. So even if you're talking about credit card debt, you can protect your home against credit card debt upon your death by doing a Ladybird Deed. Because creditors only have claims against your estate. So if you can remove that asset from your estate, you have protected it. Yes?
Is that Ladybird Deed filed right away as soon as you sign it?
Yes.
Okay, so it's a public record?
It is on public
Okay.
record.
Thank you.
I just wanted to go for the Ladybird is called transfer of
A transfer on death deed.
Yes.
Okay. There are two types of deeds. There's a Ladybird Deed, which is what I still use. There is a more recent legal development called a transfer on death deed. It is, not to get too much into the legal stuff, but there's two types of law. There's statutory law. There's a law on the books. Then there is common law, things that have been recognized as law. The Ladybird Deed is recognized under common law. Okay? It has been recognized through the courts as being legal. The transfer on death deed is now part of the Texas Code. There is a law that the legislature passed that authorized this transfer on death deed. I think they both work. I still opt to use the Ladybird Deed because there is a provision in that law that says the transfer on death deed is subject to claims for 2 years. Now, that doesn't mean the state of Texas is still going to be able to come after it. I just don't want to test the waters too much. And a lot of times, the children would like to go ahead and sell the home after death if no one's going to live there. And with the way that title companies sometimes give you fits about little nitpicky things here and there, I just would rather the home not be prohibited from being sold for 2 years or run the risk of that. I'm not saying you made a bad choice. I'm just saying why I use what I use. Okay? But to protect the house and allow for it to pass upon your death, that'll be perfectly sufficient. Okay? Yes, sir?
I did the Ladybird Deed with my home and also some other property that I had with my son. And I was wondering how that, I knew that was supposed to work. I was wondering if it would. I decided to sell some of the other property. I did, no question was ever raised about anything. Sold it. The title company did all their thing. It worked perfectly well. So it does work.
Well, good. Thank you for sharing that. Thank you for sharing that.
Ladybird Deed, yes, you wanna do it to one person.
You can deed it to multiple people. We do it a number of different ways. If it's just to a single child, a lot of times we'll just do a Ladybird Deed from person to person. There's times where, we'll do a Ladybird Deed to a simple document, to a trust document. Miss Carol does a Ladybird Deed to her Carol Trust, her Carol Residence Trust. Because you can say a little bit more in that document than you can in the deed itself. So if I have 3 kids, and maybe one of them is in poor health, or I'm worried about, well, what happens if one of them dies before me? Well, what I can do is I can do this Ladybird Deed to this simple trust document, and it would say, you know, this trust is going to own the house upon my death, and then the trust terminates upon my death, and upon termination of the trust, it's divided between these three children, and if any of these three children predeceased me, their share goes to their kids, or it goes just to the other two, or you can just say a little bit more if you wanted it to read more like a will and have those contingencies built in there. So we do Ladybird Deeds to trust as a more, you know, comprehensive way of kind of covering all your bases. And we just kind of make a determination on what works best for the client.
Since cars are so expensive now, let's say I have two expensive cars and I die, you have to wait for a probate for the cars to be, because
It depends.
you have to wait.
Yeah, it's a very lawyery answer, right? It depends. But almost everything depends, especially with what we're talking about. It depends on how the car's titled. Is it just in your name? Is it set up with you and your husband on the title with right of survivorship? If it's you and your husband on the title with right of survivorship, then it's already built in that whichever one survives owns the car. Okay? But if you're the sole person on title and you die, the title's still in your name. So the question is, you know, where does your will say it goes to? The DMV, the state of Texas, has forms where you can name a beneficiary on a motor vehicle. So did you have a motor vehicle beneficiary form already completed? If so, that can be provided to the DMV with proof of death, and they can retitle the car without going through probate. Okay? So, yeah, it just always depends. When someone passes away and they say, we need to probate the will, first thing I do is say, set an appointment, we'll come out and figure whether or not we do need to probate the will. So many times people think, oh, you know, dad died, we got to go probate, and they come in and the estate has already been completely administered because all he had were non-probate assets that passed immediately upon death. Okay? And then there's the opposite. Dad had little to nothing. He's got $1,800 in a bank account, but he didn't name anybody payable upon death, so the bank froze the account, and that's the only asset that exists. But they're going to have to spend more money to go to court and get what they need than what's in that account, and so it's basically just lost. So I've seen it play out both ways. We got to go with probate when we have very little. When we've got a whole lot, we can still avoid it. It just all depends on how your things are set up. Okay? Yes, ma'am?
My dad purchased this house when he was house and I went to sell it on his dad and create his education. He has an education trust set up. You're saying it would be better for me to do that than have him do it later, directly to his trust?
I don't know if I'm saying that now. You lead me to a great point. Because I haven't really followed my 5 mistakes, and this is one of them. No, I'm not getting onto it. All right? But this is a good thing. So he deeded it to you for what reason? Okay. All right.
I guess.
Sure, I got you. So, sometimes, we're going to skip a mistake, okay? One is people don't know how to pay for long-term care, all right? I'm just going to blend these mistakes all together. People don't know how to pay for long-term care. There's only 3 ways, remember. Insurance, private pay, or qualify for benefits. You either have insurance or you don't. If you don't, you can go figure it out. I'm not here to advise you on that. Number 2, you can private pay. We understand what that means. We either can or we can't. All right? What we don't understand are benefits. All right? Have you ever heard of Medicaid? Yes. What have you heard about it? Medicare, Medicaid, do we even know the difference? Yeah? Okay. What have you heard about Medicaid? You don't want to use it, why not? For poor people? I hear that, right? You got to be broke? You're going to take your house, going to lose your house? Going to get poor care? What is it? So, What I want you to do, I do this to everybody, I want you to think of everything that you've ever heard about Medicaid. And I want you to forget it. Okay? I want you to forget it. Because people get it so wrong. Alright? You've got to be broke to get access to assistance under Medicaid. Is that true? Depends. It depends. Alright, let's talk through it. Can you have more than $2,000 and get on Medicaid? It depends. Alright? Let's say you're a single person. Is the resource limit for Medicaid $2,000? Yes. That is a fact. That's not a it depends. It's a fact. The resource limit for a single person to access Medicaid benefits to pay for their nursing home care is $2,000. That is true.
2,000 total or 2,000?
2,000 in countable resources. So what counts? I've already said your home doesn't count. Your home is exempt. Your vehicle is exempt. Okay? I mentioned earlier, I'm working for Ross and Shoalmire. I've got a 401k. Alright? I'm not going to draw a pension. You know, law firms don't pay pensions. Pensions don't even exist anymore for people that are working now, hardly. Unless you work for, the government, or you work for the police department, something like that. But pensions basically don't exist. I don't know if Social Security is going to be around whenever I get that age. So I need to plan for retirement. I have a retirement account that I contribute to. For IRAs are exempt as a resource under the laws in the state of Texas right now and the rules for Medicare. Okay? If I have a home, and then I also have family land that I inherited, and we farm it, and I actually file a Schedule F on my taxes for farming, then the land and the equipment and the life, all that is exempt as an asset. Okay? So I could have a home and a car, and I could have a retirement account and a family farm, and a life insurance policy that only pays on my death, and a pre-need funeral, and I have zero assets towards the 2,000. Okay? Now, your money in your bank and your non-retirement accounts, all those count. Okay? But again, like I said earlier, it's better to come up with a plan to save 60,000 of the 100 than to go broke. All right? What I want you to take from this is these benefits are more accessible to you than you've been led to believe. Okay? If you're super duper duper rich, you don't need the benefits. You can afford it and it won't make a dent in what you're doing. Okay? If you're dead broke and you own nothing and your income's hardly anything, you don't need my help because you qualify right away. It's the people who have more than they're allowed to have but not enough to privately pay before they go broke that really need the help. Okay? When you're married, the $2,000 isn't the rule. It could be $27,000. It could be $127,000. I got someone qualified the other day that has $1 million. But their income is so low that they would be dipping into that every single month. And so the state's rules have a formula that says if your income is so low, you get to keep more assets. And because the interest rates are so low right now, that means you get to keep a whole lot. So I don't need you to know the rules. Okay? I need you to know to ask the questions to get the help you need if you're ever in that situation. That's what I want you to take from that. It's more accessible than you've been led to believe. You don't have to be dead broke to get access to help. Okay? Now, when you apply for benefits, you have to report everything that you own. Got a house, got a car, got a bank account, got an annuity, got this insurance. Here's bank statements, here's proof of all that. There's also a question on there that says, have you given away or transferred anything in the last 5 years? Okay? We may think that the government, and they may very well be inept and dumb and stupid and all those things, but they're not necessarily that stupid. Okay? So, why do they have that question on? Because if that question wasn't there, then every single person that ended up in the nursing home could just go out and give all their stuff away and qualify for benefits. Okay? So there's a question on there to prevent people from, oh, I'm in the nursing home, I'm going to give my stuff to my kids, and the state's going to pay for it. Okay? So, here Then the question is, when should I? I'm worried. I'm worried I'm going to lose my house. I've heard the state's going to take it. I heard I can't have $2,000, more than $2,000. I have a history of Alzheimer's in my family. I'm scared I'm going to end up in a nursing home and lose all of that. So I need to give my stuff away. When should you start giving your stuff away? Right now, 5 years before you go? Well, when do you know when you're going to go? You know? So right now, is that when you should do it? I'll make it real easy for you. This is my opinion on when you should start giving your stuff. Never. Never. Don't give your stuff away. There's just absolutely no reason for you to give your stuff away. Okay? Well, Kline, listen. What's your name? Bobby. Not singling you out, Bobby. You help me out. You team me out. Okay?
Thank you.
So, and you're a good person. Right? Well, don't doubt yourself. I'm not going to single you out. Anybody here have kids they like? Yeah? I mean, we all love our kids, but we like them all the time. Yeah? Anybody got kids that trust with their lives? Okay, what's your name, ma'am?
Janie?
Miss Janie?
Yes.
All right. Miss Janie, if you didn't know, she has angels for children. Okay? She can trust them with her life. They'd never do anything wrong. They're angels. Okay? And you can't argue with it. Okay? This is my scenario. You cannot argue with the facts that I'm putting in this scenario. I'm creating it. You can't argue with what I'm saying. We have to take that as 100% true. Miss Janie has angels for children that we can trust to never misappropriate, never sell out from under her, never spend a dime of her stuff or sell her property without her permission or under her instruction. And all she has to do is snap her fingers and it's all right back to her. Okay? We can trust that those children will not do anything with those assets that we put in their names other than hold them and safeguard them and protect them. That is the scenario. Okay? If we can be guaranteed 100% that is true, are we good? Are we good to go ahead and do that? Some people are saying yes, no. I mean, I'm setting you up. Okay? So you shook your head. Why not?
Because that person that you trust could have an accident, die, could become incapacitated themselves.
Are you just going to get all of them?
Well, whatever.
Go ahead. No, I'm sorry. You're put them all. You've already got a couple of them right there. Yeah, they're human. Great. They're human. And here, they're angels. We can trust them 100%. So those worries are off the table. We don't have to worry about them spending the money or doing something with it. We can be guaranteed that that's good. What we can't guarantee is what happens to them. Okay? We call them the 4 Ds. All right? We're in an accident. We can what? We can die. You have really good children. Angels, some would say. But if that child that you trust and you put your things in their name, if they die, now who owns your stuff? I don't know. Do they have a will? Are they a blended family? Is your stuff now tied up in court? Does it go to their kids? Do they care about you? Do they understand? Are they going to blow the money? They could die. Okay? They could be in an accident and not die and become disabled. Okay? They could be permanently brain dead from this car accident and end up in a nursing home and need to get on benefits. But now they've got all your stuff. And so now, not only is your stuff at risk, now they can't qualify because they own your stuff. So it's now been put at risk because they become disabled. You know, you live to be 90, you've got a 70-year-old child. You're in pretty good health, that 70-year-old child. 70's not too young to end up in long-term care. Okay? You could get divorced. You trust your child, but that stepdaughter, that daughter-in-law, she didn't like you in the first place. Now she's got half your stuff. Okay? They could have gotten in an accident and been really good children. I think I'm a good person, good child. I'd never do my grandmother wrong, she raised me right, all that's good. I'll protect her. But you know what I do? I make mistakes sometimes. You know, I'm driving back to the office, there's some game going on, I'm going to check the score. Or my phone went off. Maybe I'm going to send a text back. I'm going to take this call. People are on their phones when they're driving. Just so happened a little old lady was crossing the street in front of me. I didn't see her. I ran her over. Killed her. Well, her family's now going to sue me. All right? You don't do any good by giving your things away to protect them. All right? Now, again, I'm not sending you out. Hopefully none of those things will happen to you. I'm not saying it's too late for that. But what you're doing is you're availing your things to other people's problems. We have enough problems of our own. We don't need to do that. If you're worried about planning and protecting and long-term care and having too many assets, and you want to have some sort of plan in place for that, there's ways to do it. It's not willy-nilly giving or deeding or transferring assets to a person, because that person is walking around. Anything can happen to them. You do it to a trust or to some document that isn't living, it's not breathing, it's not walking, it's not driving, it's not getting divorced or married or becoming disabled. It just exists. All right? There are proper ways to plan. I'm not saying don't be charitable. You want to give things that you have that you don't want, that you want them to have, that you never want to hold on to or protect for yourself, give it away. Feel free to give. Okay? Don't give things away because you're scared of losing. Because then you might have already lost them. Okay? That's one mistake we see people make all the time. So try not to do that. Alright? Now, yeah. Yeah.
He did ask me, and I just saw it in the trust. So it would be better to give it back to him and do it to trust.
Probably. I just don't have enough information to say yes for sure. I'd want to know more before I advise you.
That's what I was.
No, there's ways to do it. Yeah, I mean, if there's a trust that exists, yeah, then it could be set up to where he owns it, it passes upon his death to the trust, or put in there now. There's ways to do it without you holding it for him and having the instruction on what to do with it.
Is that like an irrevocable trust or?
Yeah, so we use irrevocable trust planning for asset protection and long-term care planning. There's all different types of trusts, okay? There's living trusts that we use mainly for estate planning, but those have some long-term care contingent provisions in there for protection of a surviving spouse. So we use living trust planning for estate planning. We use irrevocable trusts, we call them asset protection trust, for long-term care planning. We use supplemental needs trust for disabled individuals, like children, or even a surviving spouse. We include that in all of our plans. So there's all different types of ways to do it. And that's why I said, I'm not here to tell you all exactly what to do. I don't know. I don't know your situations, what would be best. I'm just trying to tell you what not to go do, so you don't make mistakes related to that. You know, I can keep going, or I can answer questions. So where are we at? Let's go over those 5 mistakes. Okay? Let's make sure, we're going to get back on track there. And like I said, we can get off on anything you want. Number 1, don't neglect power of attorney in favor of a will. Okay? Make sure that you've addressed while you're living, and planning for while you're living, not just when you die. Okay? Number 2, kind of know what's out there as far as paying for long-term care. I've seen people privately pay for a year that could have been qualified day 1 if they would have just asked the questions. Okay? Don't assume you can't get any help, and no. So many people think Medicare or TRICARE or their group insurance or their supplement or any of those things are going to pay for long-term care. It's not. All right, so try to be prepared for that. Yes, ma'am?
A question, does Medicaid cover like memory care? You know, where Medicaid doesn't, Medicare does not cover that?
Yeah, so Medicaid can certainly pay for memory care, it just all depends. Again, there I go again, right? So, right now, you know, and I'm dealing with that myself, personally, all right? And I'm going to talk about this, and I'll talk about it some more in a minute. One thing that I have been dealing with over the last 2 years, I've been an elder law attorney now for almost 10 years. And so I've worked with people that have dementia and Alzheimer's for the last decade and helping them professionally in my job. No one in my family had Alzheimer's or dementia that I dealt with or saw personally. That's all changed. I was raised by my grandmother. My grandmother is dealing with issues of Alzheimer's and dementia now. Okay. One thing that I would say is I've been exposed and know how to navigate it and am as more prepared to deal with the issues as a caregiver, as a planner, a person of interest in this situation. I'm as prepared as anybody to deal with it. It is absolutely overwhelming, even though I am as prepared as anybody to navigate all of it. Okay? Right now, we're trying to figure out what to do with where she's going to live. It's a roller coaster. Okay? My grandmother, I was born in Texarkana, started living with my grandmother when I was 2. Same house, she lived in the same house my whole life. We decided, her son lives here, her daughter lives here, her grandchildren all live here. So we're like, she's in Texarkana, she's in her house by herself. She wasn't necessarily showing signs of Alzheimer's dementia at that time, not that we were aware of. She just wasn't doing anything. She would sit at the kitchen table and obsess over bills and watch TV and not go to church or get out or do anything, not go to the family events with the people that were still there. She was more or less secluded into her home. And we thought, you know what? It'd be great to move her down here. All of her family's here. We can see her more. It'd be great. So we talked to her. We convinced her. Okay? We signed a lease at an independent living facility. And I remember the day we signed it because it was February the 29th. Okay? So, that sticks out. Of what year? 2020. So we signed a lease in the independent living community February 29, 2020. The next week we go down there, we got a U-Haul, packed up all of the stuff we're taking with us. She moves in on a Sunday, as far as getting all of her stuff in there. I think we put her stuff in there on Sunday, maybe she went in there Monday, moved in Monday. That Wednesday, shut down. They were locked down. So we were trying to move her here to be more in tune with people, see people, do things, be in a new community, all this stuff. There for 2 days, locked down, can't see anybody, can't visit, can't go in the community. Now she's not in her house that she's always been in. She's in a 1-bedroom apartment. It's brand new to her. She's always had some underlying things, like some anxieties and some depressions and things. But it just went wild. And so her dementia progressed, her anxiety levels went high, her depression was high. We had to get people in there. She went to the behavioral unit for geriatric behavioral. We came back. We have caregivers in there, from the time she wakes up to the time she goes to sleep. We had sold her house. Now we're spending all that money. Okay. At some point, it's like we can't keep her there. It's independent living. And so the only way we're going to have people there is have someone there all the time. So let's go ahead and make this move to memory care. So she was in the behavioral unit again for the second or third time within the year. And the whole two there for 30 days. Just about. And the whole time. It was, I'm in Corsicana at the basketball game. I'm in prison. They're holding me. It's just, she had no idea about anything that was going on for a whole month. And so, I had come to the realization and acceptance of this is her baseline, and she's not going to know anything anymore. So then we made the move to memory care, and within 2 days, it's like none of that ever happened. She's like, knows everybody, doesn't remember any of it. She's just like a regular old person, regular old grandmother that knows everything. With a little bit of, cognition issues, but not full blown, I'm out of my mind for a whole month. Of course, it's some UTI, it's chronic, and it makes the dementia worse, it progresses, and so it's up and down. It's been a roller coaster for like 2 years. So eventually we're like, well, she doesn't need to be in memory care. Let's go back to assisted living. And we're in assisted living for a month, and then it's wild again, and I don't know what's going on here. So we're trying to get it all lined up, and she's back there. We pretty much have 24-hour caregiver. She's almost out of money. Okay? And so then we're going to have to make a move again soon, whether she's there or not. And we're going to have to get on Medicaid because she doesn't have a lot. She has the money from her sale of her house, and we've blown through that. And like 2 years trying to just keep her in a situation we want her to be in. I don't think she cares. We've got her one of the nicest assisted living places there is. She's like, I don't even like it. How much are we paying? And I don't want to burden her with those details. I try to not tell her, oh, it's $12,000 to pay all the caregivers and the rent and everything, because she'd lose her mind. She would much rather save that money and put that towards her grandchildren that she adores, education or something like that, But I don't want to just decide that's what we're going to do because I recommend it to everybody else. Because I need to consult everyone in my family. So it's just hard to navigate that. Your question was, does Medicaid pay for memory care? Medicaid will pay to people that accept Medicaid. All right? So if I'm going down the list of like memory cares, like the assisted living private pay memory cares, Medicaid doesn't help. Oak Hills, Meadow Lake, Azalea Trails, the Hamptons, those are all private pay assisted living facilities that have memory care. You can private pay, you have long-term care insurance. That's how you're going to go. Okay? Now, there's an assisted living that has memory care that does accept Medicaid. There are some assisted livings that do accept Medicaid. Almost all skilled nursing facilities accept Medicaid. And some of those skilled nursings have memory care. Okay? So, to say, does Medicaid pay for memory care? It depends. Does the facility that has memory care, do they accept Medicaid is the better question. But yes, you can get memory care and have Medicaid pay for it. It just depends on where. Yes. Yeah. Uh-huh. The question was, her and her father are power of attorney for her mother. Mother is full-blown, incapacitated, in memory care. They've never gotten an actual determination of incapacity. Is that necessary? It depends. So, it depends on what you're trying to do. Okay? Let's just focus on power of attorney. Certainly, if you don't have power of attorney, and someone's incapacitated, the only way you're going to get legal authority over them is by going to court and getting guardianship. And in a guardianship, you have to get a determination of incapacity. And that's the whole point. Okay? So there's that. Now, power of attorney. When would you need to have a determination of incapacity related to power of attorney? There's 2 times, in my opinion, when you would need that. One is the type of power of attorney you have. There's 2 types of power of attorneys related to the effectiveness of them. All right? One is an effective immediate power of attorney. Okay? I do power of attorney today. I appoint Miss Carol. It's effective immediately. All of the powers that I'm giving you in this document are spelled out, and you have that authority right here and now. I don't have to be incapacitated for you to have the authority. I'm giving it to you immediately. All the powers in this document you have now, whether I'm incapacitated or not. I'm going to trust that you're not going to take over my life, because I'm still doing everything for myself now. But when the time comes that you need to use it, it's already ready to roll. Okay? Or it could be a springing power of attorney. I appoint Miss Carol today, and here's all the authority I give her, but she doesn't have none of this authority is legally valid until I'm incapacitated. I give you the document, I appoint you today, but you have no authority until I'm proven incapacitated. It's springing. When this happens, now the authority is legal and ready to roll. Okay? Now, I always draft these powers of attorneys effective immediately unless I'm told otherwise. Why? We want it to work. We want to be able to use it when we need to. We don't want to have to go seek out this proof of incapacity when I'm in a major car accident in the hospital. Okay? The doctors aren't always readily available to assist me. Okay? Even if they were, sometimes they don't want to. Sometimes they don't want to expose themselves. You know, you're not designated on HIPAA, we're not going to even share the information with you. Okay? So sometimes it's hard to get that even if we are totally incapacitated. I've sought doctors' letters in guardianship cases where they say we're not going to fill it out. Even if they know we're full-blown incapacitated. I'm not saying that's always the case. I'm saying it happens. And so I don't want the person I'm appointing to have to go jump through a bunch of hoops to help. I want to make it easy. Okay? And if they do something I don't like now, just take it back. All right? So one time when you would need it is if the document says you have no authority until I'm proven incapacitated. Because if the document says that and you take it to the bank's going to look at it. They're going to say, well, you're appointed, but not until incapacitated. We don't know. You need to provide us proof.
What proof? How do we prove?
That's the whole thing. I don't know. You have to go get a doctor's letter in writing that says this person can't manage their affairs and due to whatever reasons. That's probably sufficient. Okay? Sometimes you have to go to court. I did a power of attorney. I've got it all. I have the best planning there could possibly be. I've got somebody authorized to handle all the business I need them to. Okay? Let's just go in that situation. Are there times where you've got all that in place and you still have to go get guardianship? Yes. Because I've authorized you to pay my bills and handle my affairs and make these decisions. But you know what I haven't done and can't do? I can't just forego my freedom to live where I want to live, do what I want to do. You can't take that from me with a power of attorney. I can appoint you as my financial power of attorney, my medical power of attorney, and if I'm unconscious and you can make a decision related to surgery or treatment, what you can't do is take me to a nursing home and put me there against my will with power of attorney. You can't do it. You cannot do that. So, in the event where you have done all this planning and you knew what you were doing then and you've authorized everybody to help you, but you develop dementia and you progress and you're aggressive and you're putting yourself in danger and at risk, but you can't understand the consequences, and you completely refuse help and you're adversarial to everyone and you refuse to go somewhere, that is when you may have to step in and get guardianship from the court to actually legally remove that person's right to determine where they live and what they're going to do. You have to have an attorney to get guardianship. And the court's going to appoint an attorney for the person you're trying to get guardianship over to. Alright? Let's walk through that scenario. Alright? So, let's just go, this is my last mistake. Alright? And it's by far the most common, which is just doing nothing. I'm determined to do nothing. I don't want to get a power of attorney. I can do what I want. I don't want anybody taking over my life. If I need somebody to help me, then I'll give it to them then. Well, that's a mistake. You have to have had that in place already before you need it. Okay? But the second thing, and this is kind of related to my grandmother, is don't have enough to worry about. I get that a lot. Oh, I don't need a trust. I don't need power of attorney. I'm not rich. I don't have a lot. You know, the kids can deal with it later. They can figure it out when I'm gone. I don't have anything to live with anyways. All right. Like I said, my grandmother raised me. I'm gonna walk through the scenario of what it would look like with her in dealing with this if we didn't have things in order. Okay. My grandmother's pretty nosy. Always has been. That's fine. My wife calls me nosy too. I got it from somewhere. All right. I lived in this same house my grandmother lived in for my whole childhood, all the way up through like my first year of college before I moved off. And when I got done with law school, I moved back to Texarkana. That's where I'm originally from. My grandmother lived there. My now wife that I was dating lived there. Okay. I moved in a little neighborhood very close to my grandmother. All right. And there was one day where my neighbor was like, "There's this little blue car driving by your house real slow." I'm like, "Is there an old lady in there?" It's my grandmother driving by my house. All right. Again, I lived with her in that home for 19 years. Not once in my life did we ever drive down my street that I currently live on. Okay. So I'm like, "Are you driving by the house?" And she's like, "Yeah, I was going to the post office. It's a shortcut." We never took a shortcut down that street. But she just wanted to see what I was doing. Want to see if I was there, checking in on me. She cares, all right? When I'm doing this job, I'm trying to get her stuff in order. She doesn't want to talk about her. She don't want to do it. She don't want to talk about death or will or power of attorney. She just doesn't want to do it. She don't want to talk about it at all. Eventually, I had already been practicing in Texarkana for 3 or 4 years and then moved here. And then 2 years after I was here, then she finally did the documents 5 years later. Anyways, if she had never gotten around to it, here's what it would look like as we're dealing with all this. So my grandmother doesn't have much. Okay? She had a home. She had a car. She gets a check from the Office of Personnel Management, Civil Service. She worked at Red River Army Depot. And she has a bank account that money goes into. And then she receives her income. She pays her bills. There's not any savings there. She just lives off of her retirement income. Okay? It's totally fine. She's happy with it's fine. She didn't have to have a lot. Okay? So, how does this whole situation play out if she didn't have power of attorney? Okay? So my grandmother has the need to go into long-term care, into memory care, and we need to qualify for benefits for care because she doesn't have the money to pay for it. Right? She has nothing. That's enough. Okay? I don't have power of attorney. I can't go to the bank. I can't get the bank statements I need. But she's never set up online banking. So I've got her social security number, the date of birth. I have all the information. So I just go do that. Maybe I didn't have the legal authority to do so. Who cares? You're going to set up an online bank account, get those statements, fill out that application, send it in. Show them that she is broke, doesn't have any money. And so I've got it all taken care of. Except, then they come back and they're like, you know, the deposit of her retirement income is less than the limit, but that's her net deposit. And we judge her eligibility based upon her gross income. So we need a statement from the Office of Personnel Management that breaks down her annuity. We want to know her gross pay minus any withholdings for taxes or insurance or anything else. So now I have to get that. And they're not so anxious to give that to me when I call them. And the other thing they noticed is on her bank statements, there's a $3 draft for Globe Life and a $5 draft for Globe Life and a $12 draft for Transamerica and all this stuff. Turns out, she's got a life insurance policy on every grandchild. None of them worth anything. But I've got to prove that they're not worth anything. So I'm going to have to contact these insurance companies and get proof of these policies and their cash values to show that they don't add up to put her over the limit. I have to deal with them. So now I'm needing to get a bunch of stuff I can't get. all right? And so because I don't have the legal authority to go get those things, now I have to sue my grandmother. I know that that sounds harsh, but it's reality. I have to file suit in the county seeking guardianship. I have to go hire someone like myself to file that application that alleges my grandmother is incapacitated, that she can't determine where she lives, that she can't pay her bills, she can't manage her care or her estate. And so the court is legally required to appoint an attorney for her. So now there's two attorneys involved in filing fees and court costs. And let's say everybody's on the same page. Myself, all of her children, we all agree she's incapacitated. We all agree that I should be the guardian. There's no infighting. It's just smooth on that end. We contact her doctor. They're able to get us a doctor letter as soon as we ask for it. We don't run into issues or hurdles there. Everything goes as smooth as possible. It's still going to take 3 months to go through the process. We're going to spend at least $5,000, $7,000, $10,000 on the expenses of the guardianship. And all the while, we're in the nursing home, not on Medicaid, accumulating private paydays for 3 months. So now I've got a $15,000 bill there. Next thing I know, we've spent $20,000, $25,000 to go get the proof that we have nothing so that we can qualify for benefits. And whose burden is that on now? Her children. Because she didn't own anything. She doesn't have anything. She doesn't have money. So it's taking simple steps to help those people you care about help you if you need to. And it doesn't matter how much you have and how rich you are. If you have anything in your name at all, you need to have power. You need to have someone help you. Okay? All right. I think our time's up. So I'm going to quit talking. But if anyone has questions, I'll answer them. And if you need to go, feel free to. I'm not going to get offended if you walk out. Typically, what we do is every single person does their own power of attorney. So you have a power of attorney, your husband has. It could be the same person. Certainly can.
Thank you so much.
Oh, no problem.
Thank you all for coming. If you have not signed in, please do so. That really helps us out. And there's some extra lunches if you go and want to take one home. And if you would fill out the worksheet evaluation on the back of the notes page, yeah, that would really help us out. Thank you guys so much for coming.